Welcome everybody to CHK Law. Welcome to this week's Greater China Legal History seminar. Before I introduce the speaker, allow me to mention that at the end of the seminar, we will have a Q&A session. If you have any questions, please use the chat function, chat them in, and I will read them out to our speaker. My name is Ulrike. I'm a professor here at CHK Law. Now, it's my great pleasure to welcome today's speaker, Dr. Ulrike Glueck, who studied law and graduated from Passau University in Germany. She studied at the East China University of Politics and Law from 1988 to 1989, and in 1993 spent again time at the East China University of Politics and Law for researching this topic, the topic she is talking about today. She received a doctorate degree from Passau University in 1997, and the topic of the thesis was obviously the Dian. In 1996, she was admitted to the bar in Frankfurt, Germany, started to work in private practice. She has been working in Shanghai since 1998, specializing in corporate law and M&A. She is now the managing partner and head of the corporate practice area group and TMC sector group of CMS in China. Dr. Glueck is, if I may say so, one of the towering foreign lawyers in Shanghai, highly successful, respected by Chinese and by foreign legal and business circles. She is one of the smartest and toughest lawyers I've ever got to know. And of course, as a managing partner of such a busy law firm, she herself is extremely busy, and we are extremely grateful that she has found the time to present this talk today. Dr. Glueck will talk about the Dian, a pre-revolutionary security right with post-revolutionary implications. And this is, of course, a fascinating topic from the historical perspective, but also from a doctrinal point of view, as we will see later. But I don't want to talk too much. Over to you, Ulrike.
Okay. Also a very warm welcome to today's lecture on the Dian, and thank you very much, Lutz, for your extremely friendly introduction. I'm very happy in your interest in this subject, the Dian, and that we have so many participants today. So let me share now my presentation. The title of our lecture describes it as a pre-revolutionary security right with post-revolutionary implications. The term Dian refers to the following situation, which you can see here on this slide. An object is transferred to the creditor for use in return for payment of a sum of money, the so-called Dian price, Dian jia. The Dian giver or Dian debtor can later redeem the Dian object in return for repayment of the original Dian price. No interest is paid during the term of the Dian, and the interest payment by the Dian giver is basically replaced by the use of the Dian item by the Dian creditor. Before this lecture, you probably have never heard about the Dian. So no worries. Before I started to do research on security rights in China back in 1993, and then ended up to focus my research on the Dian, I had also never heard of it. And to be frank, after I finished my PhD thesis, I never followed up on the Dian until late last year when I was invited by you, Lutz, to give a lecture in the CUHK series on greater legal history on the Dian. So thank you very much, Lutz, for this opportunity to revisit what I had researched and written about 30 years ago. In fact, the Dian is a Chinese legal institution with a very long tradition. It was probably already known in China in the later Han period, that was 25 to 2020 AD, but certainly since the Tang period, that was started from 618 AD and became very widespread in the Song period, which started in 960. In the past, legal institutions of the Dian type were relatively widespread in agrarian societies all around the world. As a rule, these were liens on land. There are parallels, for example, in Babylonian law, in Korean law, the vivgage of the old French law, the mortgage of the old English law, and the so-called older statutes of medieval German law. While all these legal institutions already a long time ago became only of historical interest, the Dian continued to exist into recent times. In PRC case law, the Dian can be traced at least until the early 1990s. And in the Civil Code of Taiwan, the MINFA, regulations still exist until today. Sorry, I want to move the slide. Yeah. Especially for the period of traditional Chinese law, the classification of the Dian into known legal categories causes a lot of difficulties. In particular, it is quite difficult to distinguish it from a pledge. The Dian is usually classified as a security right. It is characterized as a real property security in the form of a usufructory right, as opposed to a non-possessory lien on real estate and a lien on movable property. Let me go back in the slides, because I would first like to give you a short overview of what I'm going to talk today. I will first give you an overview on the traditional Chinese legal system and its legal sources. Then I will talk about the Dian in imperial times, in particular during Qing dynasty. As you probably most of you know, Qing dynasty was from 1644 to 1911. The third part of my lecture is an overview over the Dian during the Republic. That was from 1911 to 1949. Then I will give an overview on the Dian in the PRC, so since 1949. And finally, some words on the Dian today. The Chinese legal system underwent several fundamental changes in the 20th century. So traditional Chinese law, which is mainly composed of the provisions of local common law, was replaced during the Republic by a civil code, a written civil code, the MINFA. I will come to that later. The founding of the People's Republic of China in 1949 led to another fundamental change of the legal system. All laws and regulations issued under the previously ruling Kuomintang were repealed in September 1949. Initially, this was a purely formal act. The existence of the Dian continued to be recognized in practice. However, in the mid-1950s, the abolition of private ownership of land deprived it basically of its actual basis. Civil law was not regulated by law in the PRC again until the Minfa Tongzi, the General Principles of Civil Law, came into force in 1987. However, this does not mean that the Dian no longer played a role in the law of the PRC in the initial years. I will show you some details later. Now to the Chinese legal system. The traditional Chinese legal system differs considerably from the European Western understanding of law. With regard to civil law, the prevailing opinion of scholars is that there was no separation between criminal and civil law, or another opinion says that civil law did not exist as an independent legal matter at all. In fact, the existing laws were criminal law in form. Codified law existed mainly in the form of criminal sanctions. Although there were norms whose regulatory content was basically civil law matters, such as sale of land, marriage, adoption, succession, etc., but they were usually presented in a criminal law garb, which means formulated as prohibitions with a threat of punishments. The following example may serve to illustrate this. The appointment of a Dian and the sale of fields and buildings had to be registered. The obligation to register was on the Dian creditor or the buyer. The relevant legal provision in this case was not Dian and the purchase of fields and buildings that are not registered are invalid, but rather anyone who acquires a Dian on fields, so land, or buys them without having the contract registered, receives 50 cane strokes. He must pay the registration fee and an additional sum equal to half of the price. So you can see the facts of the case were for sure civil law matters, but the legal consequences of non-compliance were criminal sanctions. Historical Chinese law remained largely unchanged over centuries. This applies in particular to written law, which consisted of the codes of the respective ruling dynasties. Back in the 90s, when I did my research, the first traceable written law which I found was the so-called Xing Book of Punishments, that was issued in 536 BC in the state of Zheng. The first uniform form code of law for the whole of China was the code of the Qin dynasty. So you all know, of course, Qin Huangdi. That was about 200 BC. And subsequently, each following dynasty issued its own code of law. From the Song to the Yuan and the Ming and Qing dynasties, all codices were more or less based on the Tang code, the Tang Lü Shu Yu. The Song and Yuan, and initially also the Ming, adopted the code of the previous dynasty largely unchanged in form and content. Only the Ming Code of 1397 broke with this tradition by reducing the number of main laws by a third and radically changing the division of the code. Instead of the division into 12 chapters, it was now divided into 7 books and 30 chapters. The main legal source at the end of the 19th century was the Qing Dynasty Code, the Da Qing Lü Li. The literal translation is laws and decrees of the Great Qing. The Qing Dynasty came into power in 1644. An imperial decree from the same year stipulated that the Ming Dynasty Code, the Da Ming Lü, should continue to apply, however adapted to changed circumstances. Then in 1646, the Da Qing Lü Jijie Fu Li, the Code of the Great Qing with commentary and appended decrees, was enacted. And then in the middle of the 18th century, Qianlong came into power, and under his reign in 1740, the code was fundamentally reformed. The Da Qing Lü Li consists of 7 main parts. You see them on this slide: the Ming Li Lü, the Shi Lü, the Hu Lü, the Li Lü, the Bing Lü, the Xing Lü, and the Gong Lü. And basically, these chapters, they follow the ministries they had. The first part, the Ming Li Lü, can roughly be translated as concepts and general principles, which means it's a kind of like introduction, a kind of general part. The regulations for the Dian are mainly contained in the Hu Lü, which is usually translated as Ministry of Taxation and Population. The Dian was mainly governed in Chapter 2 of Book 3, the so-called Hu Lü Dian Chai, in Lü 6, which has the title Dian Mai Dian Chai, so Dian and purchase of fields and buildings. Now, what was the object of a Dian in the Qing Dynasty code or during Qing Dynasty? In other words, on which items could a Dian be established? Only on real estate or also on other objects? The question is preceded by the issue whether the division into movable and immovable property was even known in traditional Chinese law, and whether a strict distinction was made at all between these two categories. Because basically these categories probably come from Western law and are part of our current system. There are some doubts whether the distinction was known at all, because the same terms were used for the Dian and also for the Lian on movable property. So the Dian was also sometimes called zhi or dang. The Lian on movable property was called zhi dang jie ya jian or jian dang. Some of you may be familiar with the term jian dang. It is currently used for pawn shops. For the basically pledge of movables as security for a loan obtained. I mentioned that the continental European legal system distinguishes between movable property and immovable property, which are movables, and immovable property, real estate. Whether traditional Chinese law also thought in these categories is disputed. What is certain is that the terms used today for movable property, which is dongchan, and immovable property, budongchan, were not known in traditional Chinese law. They are terms derived from Japanese law, which were introduced in China as part of the attempts to reform the legal system at the beginning of the 20th century. The previously applicable laws and Chinese foreign language dictionaries published before this time did not mention these terms. Chinese legal historians are of the opinion that a classification into two different categories equivalent to this distinction was nevertheless quite common. In any case, in ancient times, a Dian could not only be established on fields and buildings, but, for example, also on carts and boats, which under our understanding of today qualify as movables. How was a Dian established? Usually by conclusion of a Dian agreement. And the establishment was usually recorded in writing by the parties involved. The details were as follows. When a Dian was set up, two separate written declarations were made. The debtor issued a Dian letter, the so-called Diandang Chengqi, literally front Dian contract, or Diandang Shangqi, literally upper Dian contract. It included the name and place of residence of the debtor, name and place of residence of the creditor, the amount of the Dian price, the size and description of the Dian object, and the time limit of the legal transaction, which means the term of the Dian and possibly the start of the redemption period. The debtor often additionally stated that the Dian object was his property and had not already become the subject of another Dian agreement. It was also mentioned sometimes that the debtor had initially offered the Dian item to his relatives, and these have refused to conclude a corresponding legal transaction. The Dian letter was signed by the debtor, a witness, intermediary, and delivered to the creditor together with all property titles. Titles of ownership were, for example, bills of sale or deeds from previous transactions, leasehold notes, or permits to cultivate the land. The transfer of the Dian letter and the title documents to the creditor was in principle an indispensable prerequisite for the conclusion of the legal transaction. The Dian price to be paid by the creditor was lower than the actual value of the Dian object. As a rule, it was usually between 60% and 80% of the sales value. The priority right of relatives and neighbors, Qinlin, seems strange from today's perspective. This was rooted in the traditional Chinese idea that the most important economic assets, which primarily were farmland and buildings in these agrarian societies, were not owned by the individual, but by the family. Contrary to the centuries before, in Qing dynasty, the establishment of a dian did not have to be reported to the authorities. The official registration of the agreement by attaching the so-called qi wei, which is a kind of official certification of the contractual agreement, and the associated tax were no longer required. So by paying the dian price, the dianjia, the creditor acquired the dian right, the dianquan, and this process was called chengdian, so taking over the dian. Now, what were the legal positions, the rights and obligations of the parties? Basically, these were not stipulated in statutory law, but all rooted in customary law. During the term of the dian, the creditor had the following rights: the right to possess and use the dian object, as well as the right to reap its fruits, the right to dispose of the dian object to a certain extent. For example, the creditor could rent out the dian object. Interestingly, not only to third parties, but also back to the dian debtor. If the dian object was handed over to a third party, the original dian relationship remained in place. The debtor could then only redeem the dian from the third party via the creditor. The creditor had also a priority right in case of sale of the dian object, so a right of first refusal. The dian creditor's obligations were also not regulated by statutory law, but under customary law, he had the right to possess the dian object, and that corresponded to the obligation to maintain and manage it. In principle, the creditor had to bear the costs for the maintenance and renovation of the dian object. If the dian object was a building, however, it was customary for the parties to agree otherwise. The costs were borne by the debtor or half shared or first advanced by the creditor and later at the time of redemption reimbursed by the debtor. It is unclear whether the creditor also had to pay the property tax and other state taxes, because as I mentioned before, the contracts no longer had to be recorded. What was the liability for loss of or damage to the dian object? That also was not regulated by statutory law. There is an ordinance of 1915, so strictly speaking, already after the end of the Qing dynasty, but it is we can assume that this basically reflected the customary law that had been in place before. And this ordinance stipulated that no compensation had to be paid if a building was destroyed or damaged by fire. This shows that the legislator assumed that neither the debtor nor the creditor was at fault. In other words, the ordinance regulated the allocation of risk for accidental destruction or accidental damage. The following distinctions were made in detail. If the contractually agreed date for the start of the redemption right had not yet been reached, 3 alternatives had to be considered. If the creditor and the debtor each paid half of the costs of reconstructing a building, the term of the dian was extended by 3 years, which means the start of the redemption right was postponed by 3 years, and the debtor was then able to redeem the object at the original price. If the debtor was not in a position to bear his share of the cost and the creditor financed the restoration of the building alone, the term of the dian was also extended by 3 years, but on redemption, the debtor had to pay a redemption price that was 40% higher than the original price. If the creditor was not in a position to bear his share of the cost, the debtor was able to redeem the building on the originally agreed date, and the redemption price was 40% lower than the original price. The ordinance also contained stipulations what happened if the contract period had already expired. But with contract period, I mean the term of the Dian, but the object had not yet been redeemed. Here, the ordinance also distinguishes between three scenarios. First, the debtor could redeem the Dian object immediately for half of the original price. If the debtor did not have the financial means required for redemption, and the creditor rebuilt the building at its own expense, then the term of the Dian was extended by 3 years. And if the debtor later redeemed it, he had to pay a redemption price that was 40% higher than the original price. If the debtor and the creditor both did not have the means to rebuild, then the land on which the destroyed building was located could be sold. And this possibility regardless of whether the contract period had expired or not. The debtor then had to pay the creditor 1/3 of the proceeds received. Next topic is the term of the Dian and the redemption. A big topic for centuries was always the term of the Dian, which means when the Dian object could be redeemed and for how long. The legal position of the creditor was subject to a condition subsequent. The debtor could redeem the Dian object in exchange for the sum of money previously paid to him. The point in time at which the debtor could exercise the redemption basically depended on the content of the agreement made by the parties. In the absence of a contractual agreement, the debtor could theoretically redeem at will at any time. However, in fact, in traditional Chinese law, redemption was limited by customary law to the period between harvest and sowing. And as a rule, the term of the Dian was agreed contractually by the parties. It was agreed that the Dian was to be limited to a certain number of years, after which the debtor could then redeem it. The term time limit does not accurately describe the essence of the provision. In fact, the contractually stipulated date did not refer to the end of the term of the original agreement, but to the beginning of the redemption right. So the term of the Dian was basically unlimited, but the debtor's right of redemption did not end on the date specified in the agreement. It only began. So it was the beginning of the redemption right, and this redemption right was limited in time. Redemption was a right of the debtor and not an obligation. The creditor had no means of forcing him to do so. He could not demand repayment of the sum of money provided, nor did he have any right of enforcement into the property. If he was in financial difficulties, he could only appoint a sub-Dian or rent out the object. The exact amount of the redemption sum was determined by the extent of the payments made by the creditor. The debtor had to pay the amounts paid by the creditor. If the debtor had received an additional payment, he also had to repay it. If the creditor had erected value-enhancing installations and had not removed them before returning the Dian object, the redemption sum was additionally increased by the estimated value of these installations. If the value of the Dian object had deteriorated as a result of damage, the redemption sum was reduced by the corresponding amount. I think I need to go to the next slide. No, sorry. Originally, redemption was not subject to time limits. This led to a complete blurring of the distinction and boundaries between Dian and sale. In 1753, the Dian term was limited to 30 years, a decree from 1770, that was the 35th year of the Tianlong reign, further limited the term of the Dian to 10 years, and a tax ordinance from 1906 increased it again and stipulated a maximum term of 20 years for the Dian. I had already mentioned that in late Qing dynasty, the distinction between Dian and sale became a bit blurred. At the end of the Qing dynasty, in traditional Chinese law, apart from the Dian, there was also a sale subject to repurchase, so-called huomai. Dian and huomai differed in only two aspects. First, in the question of the official registration of the conclusion of the contract, and the registration of the or description of the subject of the contract in the land register, and second, in the term, in the question of the term of the legal transaction. So official registration of the conclusion of the contract and transfer of the subject matter of the contract in the land register were only required in the case of sale subject to repurchase. And the land register was also used to record who was liable to pay land tax. The owner of the land was liable for the land tax. And from the fact that the registration fee was paid and the property was transferred from the debtor to the creditor, it can be concluded that ownership was transferred to the creditor in the case of a sale subject to repurchase reservation. In the case of a Dian, on the other hand, the debtor remained the owner and the creditor was only the holder of the right of possession and use. The second difference concerned the term of the agreement. I had already mentioned there were some changes in later Qing dynasty. It was limited to 10 years and then increased to 20 years again. And after that, redemption by the debtor was excluded. Whereas in case of a sale with a repurchase option, at least theoretically, repurchase was, or also in practice, repurchase was also permitted at a later date. Not only the distinction between Dian and huomai, so sale with right to repurchase, is a bit blurred, but also the distinction between the Dian and a lien on land and buildings, which was generally a non-possessory lien. The terms used for these two legal institutions also overlap to some extent. I had already mentioned that Dian was also sometimes referred to as zhi or deng. The non-possessory lien on real estate was called ya, zhi, deng, di deng, zhi zhan, or lai. In traditional Chinese law, same as today, a real estate lien or mortgage was understood to be the encumbrance of a plot of land or building to secure a loan. In contrast to the Dian, the debtor usually remained in possession of the mortgage property and paid interest to the creditor. The mortgage was not regulated by statutory law. It was neither mentioned in the Dating Lu Li nor in its commentaries. Western literature generally concludes from the lack of legal regulations or statutory regulations that mortgage in China is only of recent origin. However, the non-possessory lien on land and buildings was already known in China at least since the time of the Liang dynasty, that was 502 to 557 AD. This can be seen in chapter 51 of the History of the Southern Dynasties, in which the following incident is described. In the city where Hong, that was a prince of some feudal state, had his headquarters, there were several tens of families who had borrowed money from him out of need. They had all agreed in writing to make their fields, houses, or stores available to him, if payment was not made on time. When the deadline expired, he drove out the debtors and took possession of the houses. So that is clearly describes the situation of a mortgage. So finally, what was the legal nature of the traditional Dian? There is agreement that it was a limited right in rem if we want to classify it in the categories commonly used today. What form it actually took, however, is disputed. There are two opinions. The vast majority of both Chinese and Western scholars characterize the traditional Dian as a security right. The Dian was a lien of use. The main reason given for this is its legal historical development, and that the terms Dian and Zhi, which means pledge, were never clearly distinguished. According to another opinion, the traditional Dian was a usufructuary right. The originally used term Dian Mai proofs this opinion argues the originally used term Dian Mai proves that the legal relationship between Dian and sale were the same, and they did not have the character of security. The Dian price was not a loan, but consideration for the Dian right, and the Dian was not accessory. If the value of the Dian object had fallen during the term of the Dian, the debtor did not have to provide any additional collateral. However, the following items are difficult to reconcile with the classification of the Dian as security interest. The Dian often did not have the function of a means of security, but served to establish a lease-like relationship. The focus of the Dian contract was not so much on the payment of the Dian price, but on the transfer of possession of the Dian object. And the Dian was not accessory. The unusually strong legal position of the debtor also speaks against the legal nature of the Dian as a pure security right. He could not demand subsequent payment. The time limit for the commencement of the redemption right does not serve to protect the debtor, but rather the creditor. And the creditor had no possibility of forcing the debtor to redeem the Dian object. Originally, the Dian of land and buildings was probably merely a way of raising money while circumventing the social taboo of a final sale of land. Later, it probably became apparent that this legal institution was also suitable for fulfilling other functions, for example, that of a pledge or lease due to its special structure. And these special characteristics of the Dian in traditional Chinese law, in my opinion, are probably best accounted for by classifying it as a legal institution sui generis. So far to the Dian in traditional Chinese law. I now come to the Dian during the Republic of China, 1911 to 1949. Basically, the Republican law was divided into two phases in terms of form and content. The law before and after the enactment of the Republican Civil Code, the Minfa. The Minfa came into force successively between 1929 and 1931, and it broke almost completely with the previous legal tradition, and therefore really represented a radical turning point. There had already been attempts in the last year of the Qing dynasty to reform the legal system. The first attempt resulted in the drafting of a civil code, the so-called Da-Qing Minlü Cao An. The draft was completed in 1911, but as a result of the abdication of the Qing dynasty, it never came into force. In this draft, the Dian had no longer existed. This draft instead provided a lien, a pledge on real estate. However, in 1915, there was still some legislation also covering the Dian. I had already mentioned this ordinance you see here. which regulated in particular the term of the Dian. Then there was also an ordinance from 1922 which required registration of a Dian in the future. And then, as I mentioned, between 1929 and 1931, the MINFA was enacted, and the Dian was included in the MINFA, in the 8th section of the 3rd book of MINFA, in property law, and stipulated in articles 911 to 927. I already mentioned the MINFA. It was basically adopted law and based on the Japanese law, and the Japanese law was based on the Swiss civil law and the German civil law. So basically completely different system. And but the legislators did not press the traditional Chinese legal institution of the Dian into a form familiar from the legal systems that served as a model. So basically, the Dian was incorporated into the MINFA in its more or less traditional Chinese form, and was one of the few traditional Chinese institutions that I would call survived this reform. I have included in my presentation the text of the articles, and I will not, of course, will not read them. I understand you will get the PowerPoint after this lecture, and then you can read them in detail. Article 911 MINFA contains the definition of the Dian. A Dian is the right to take possession of another's immovable property in return for payment of the Dian price, to use it and to benefit from its fruits. So it is very clear, unlike in traditional Chinese law, the Dian can no longer be established on carts or boats, etc., on movable property, but only on immovable property. There are 3 forms of legal establishment of the Dian: the creation of a new Dian and the transfer of an existing Dian by either way of assignment or succession. The basis of the Dian is a voluntary agreement between the parties, the Dian debtor and the Dian creditor. The subject of the contractual agreement is the right of the Dian creditor to take possession of the Dian object in return for payment of a certain sum, the Dian price, to use it and to draw its fruits. The exact amount of the Dian price is determined by the contracting parties, usually between 50% and 80% of the value of the Dian object. What is new is that the establishment of merely indirect possession was also sufficient. Now, since under the new legal structure, this is classified as a right in rem. So the establishment of a Dian had to be made in writing. And since it is a right in rem, the establishment took only effect after registration. So again, what were the rights and obligations of the parties? You see them here, and since time is moving forward, I will actually shorten a bit. I just want to point out that the MINFA also contained already back then detailed stipulations on the right to appoint a sub-Dian and to rent out the Dian object. So a sub-Dian could only be created during the term of the Dian. The term of the sub-Dian must not exceed that of the original Dian. and the price agreed for the sub-Dian must not exceed the original Dian price. And if the Dian object was damaged as a result of establishment of the sub-Dian, the Dian creditor was obliged to pay compensation. One interesting new development was that under certain conditions, the Dian creditor could demand compensation for the use of the Dian object at the time when the Dian object was redeemed for certain expenses, like for necessary expenses, useful expenses, or expenses for the reconstruction or repair of the Dian object. There are detailed stipulations what are useful or necessary expenses. I will not go, due to time constraints, I will not go into details. I will also skip over the rights of the Dian creditor, very similar to the traditional times. Very short rights of the Dian debtor. He had to still the right to dispose of the ownership of the Dian object, and this is new. He had the right to create a mortgage on the Dian object. And the obligations of the Dian debtor, where he was liable for ensuring that the Dian object was free of legal and material defects. And I already mentioned that under certain circumstances, he had to reimburse certain expenses of the Dian creditor. Liability for loss and destruction is also clearly regulated in the MINFA. I refer you to the relevant articles they are in Article 920 to 922 of the MINFA. The MINFA also contained back then and still contains detailed stipulations on the term of the Dian right. In principle, the duration of the term of the Dian is subject to the parties' agreement. However, according to Article 912, MINFA cannot exceed 30 years. If the contractually agreed term of the Dian was longer than 30 years, it was shortened to 30 years. The term of the redemption right is limited. The exact duration of the terms depended on whether the parties had contractually agreed on a term for the Dian or not. If a term had been contractually agreed for the Dian, then the redemption period was 2 years after expiration of this term. Otherwise, the Dian creditor acquired the ownership of the Dian object. So there was, otherwise, the redemption right was forfeited in modern terms, so to say. If the parties had not agreed on the term for the Dian debtor had to redeem the Dian within 30 years of the Dian, of the starting point of the Dian. Otherwise, the redemption right was also forfeited. Short remarks to the termination of the Dian. I had already mentioned several times, after end of the term, the Dian debtor can redeem the Dian. The Dian creditor, in case of redemption, can remove his plants and plantings, but does not have to restore the former state of the Dian object. The following situations also led to the extinction, to the end of the Dian. If the Dian object was during the term of the Dian destroyed in whole or in part by force majeure, if the Dian creditor waived the Dian, the parties could agree that the Dian creditor could sell the Dian object to a third party if the Dian debtor failed to redeem it on time, and the sale then also extinguished the Dian. And of course, Dian also lapsed, so to say, if the ownership of the Dian object and the Dian merged in the same person. In In the Republican era, the distinction between Dian and mortgage was easy because the mortgage was and is also specifically stipulated in the law. And yeah, what is the legal nature of the Dian in Republican law? It is undisputed that it is a limited right in rem. Questions are still, is it a security right or is it a right of usufructus? And that is actually the prevailing opinion amongst Chinese legal scholars, at least what I found out until the beginning of the 90s. In my opinion, the Dian does not fit seamlessly into the category of usufructuary rights either. Because it's a bit difficult to reconcile with the form of the redemption right. If the Dian price itself is considered as consideration for the creation of the Dian, and in particular the granting of the right to reap its fruits, the return of the Dian price should not actually be necessary for the expiry or for the end of the Dian. The fact that the Dian debtor must repay the original Dian price upon redemption is similar to the redemption of a claim. In my research back then, I also came to the conclusion that it's probably more justified to retain the characterization made for the traditional Chinese Dian, also for the Dian under the Minfa, and to classify the Dian of the Republican Civil Code also as a sui generis right in rem, as a right sui generis. So time is moving forward. So I very shortly now come to the situation in the People's Republic. I already mentioned that in 1949, all Republican laws were repealed. However, the Dian legal relationships, both those from the former Republican era, as well as those that were created after 1949, continue to exist. And we have quite a considerable number of statutory law and decrees on various individual aspects of the Dian issued at the beginning of the 1950s. Then from the mid-1950s, the importance of the Dian declined. The reason was that there was the reorganization of the economy, including the abolition of private ownership of land, the restriction of private ownership of buildings, and this more or less eliminated the basis of the Dian. But at least in the early decades of the PRC, the Dian never completely disappeared from legal reality, because Dian rights could still be granted at least on buildings owned by private individuals. And the Dian rights that existed from earlier times also repeatedly gave rise to disputes between the parties to the contract. So here is a short overview on the statutory laws that were enacted on the Dian in the, especially you see here in the 50s, mainly all in the 50s. Strangely, still some provisions on the taxation of buildings that also mentioned the Dian in 1986. But the main legal source or the main proof, and also basically legal source of the Dian since then, starting from, I would say, the late 50s, is case law. Since the founding of the PRC Supreme People's Court has issued more than 40 decisions on the Dian. these decisions or rulings are not uniform in nature. They also go under different titles. Essentially, 3 types of decisions are available, each in different numbers. On the one hand, we have Dian, literally opinions. So in total, I had analyzed 42 decisions of the PRC Supreme People's Court, and 4 of them are so-called Dians, so opinions. And then we have, of these 42 decisions, we have 14 decisions titled Fuhan or Hanfu. This literally means reply letters. And of the 42 decisions available, we have 24 decisions titled Pifu. This literally also means reply, and this is the reply to the request of a subordinate authority. So there were some disputes, and subordinate court or subordinate authority handed over or handed up, submitted the dispute for decision to the Supreme People's Court. And on the next slides, you see the list of these 42 decisions I had analyzed for my thesis. Actually, they are marked in different colors. So Pifu, so the replies to subordinates, are colored here in this red shade. Then we have the Fuhans, the answers, replies in gray shade. And somewhere we have opinions, yeah, which is supposed to be a different shade. So I won't read them out. You are welcome to read through the slides later, and you can see from some of the titles, the description, you see already what they are about. So basically, many of them, they relate to disputes on whether the Dian object, so they more or less all relate to cases, to Dian relationships that had been established before 49, and the majority of the cases relates to disputes over the questions: was the redemption period over? Could Dian object still be redeemed? What was the price? For example, the Dian was established under the currency a century ago, and so how was the price then to be the price to be paid for redemption still to be calculated? Then questions as to the building or the land had been expropriated by the state. Could it still be redeemed? Basically, mainly, or a new building was erected or upgraded, etc. What was the Dian price? So the decisions of the SPC all more or less all relate to Dian contractual relationships that had been established before 1949. I had already mentioned that there was, during the 50s, pretty complete expropriation of private ownership of land. And that, of course, restricted the scope of application of the Dian. And later Dians could, in fact, only be established on privately owned residential buildings. And I already mentioned that all the cases handled by or dealt with by the Supreme People's Court were referred to transactions that had been made before 1949. So more or less all parties involved had acquired their rights through inheritance. So how were these issues dealt with? First, rights and obligations of the parties. Since the beginning of the PRC, the Dian creditor, in accordance with the previous law, had to bear the property tax liability. One of the decisions of the Supreme People's Court also covers the issue of liability for repair costs. According to a reply of the SPC in 1951, if there is no contractual agreement to the contrary, minor repairs are to be borne by the Dian creditor, and major repairs, for example, the costs of rebuilding a partially collapsed house, by the Dian debtor. If, contrary to this principle, the Dian creditor had also paid for major repairs, the Dian debtor had to reimburse him for these expenses upon redemption. While the legal position of the Dian creditor has been the subject of legislation and court decisions in several cases, of the rights and obligations of the Dian debtor, only the redemption right has found its way into case law. I already mentioned many decisions of the Supreme People's Court refer to disputes concerning the exercise of this right. Oops, sorry, that was now apology. Can you still see it? Please bear with me. I need to somehow get back.
You
Please
could
bear
just
with me.
restart.
I somehow have a bit technical difficulties. 1 second, please. Can you still see my presentation?
We only have the first page, but you could probably just stop your PowerPoints and restart it, and then.
Yeah, probably. Let me just try it. Okay.
Yeah, here we are.
Okay. So there are some opinions of the SPC from 1983, which provide that the parties could agree on an extension of the contractually agreed term of the Dian. So we come to the topic, how long is the Dian and how can it be terminated or redeemed? I had mentioned before that the upper limit for the contractually agreed term of the Dian contracts was defined in the method of the Ministry of Finance for the taxation of Dian contracts, which was issued in 1952 to be 20 years. The decisions of the SPC of the Supreme People's Court vary a bit. There is a reply of the SPC in a case handled in 1963, which states that the redemption term had to be decided based on the actual situation. And then we have another decision of the SPC, an opinion of 1984, which stipulated the term was 30 years. A big topic was also always what happens to buildings that had been expropriated. From a legal point of view, it seems evident that only a still existing Dian can be redeemed. But a lot of disputes arose in connection with Dian contracts. that had already been annulled by the state during the land reform or during the expropriation of urban residential property. And the SPC, the Supreme People's Court, and various authorities have dealt with this issue in several decisions. Their decisions were all very clear. The situation created by the land reform remains unchanged. The ownership of properties on which a Dian had been created by landlords or other persons subject to expropriation was excluded. If no expropriation was carried out, ownership was not transferred to the state, and the Dian could still be redeemed. When redemption was still possible, the Supreme People's Court, in opinions of 1963 and 1979, also always considered the situation, the actual situation of the contracting parties. Basically, if they considered whether the Dian debtor who wanted to redeem had already existing housing or not, or whether the Dian creditor after redemption would basically be homeless. So the decisions or the opinions of 1963 and 1979 stipulate that if the Dian creditor would not have a house to live in after the redemption, but the Dian debtor does not lack housing, the redemption can be postponed or only a part can be redeemed, or the residential building can be sold in whole or in part to the Dian creditor. The redemption, also according to the SPC cases, is only effective if the Dian debtor repays the Dian price to the Dian creditor. In principle, a sum corresponding to the original Dian price must be paid. And if the parties have increased the Dian price during the term of the Dian, which is permissible according to the case law of the SPC, the increased price must be repaid. However, I had mentioned several times the majority of the Dian legal relationships had existed for a very long time. And the question arose whether the general development of value and inflation should be taken into account when redeeming them. In the case of Dian contracts concluded before 1949, there was also the problem of currency reform. The currency in which the original Dian price was calculated at that time had long been abolished. There are some statutory stipulations on this. We have an instruction from 1950 that in such cases, the corresponding amount of the currency valid at the time of redemption was to be paid. And there is an opinion of the Supreme People's Court in from 1979 that the conversion of the Dian price should in principle be negotiated by the contracting parties. If they are unable to reach an agreement, the conversion should be made in accordance with the value stipulated in state regulations, taking into account the economic situation of both parties, their housing situation, and the purpose pursued with the redemption. Now, the term of redemption. The statements by authorities and courts on the question of the term of the redemption right were initially inconsistent and generally did not contain a precise time limit. According to a reply of the SPC, the Supreme People's Court, from 1951, if a term was contractually stipulated for the Dian and the redemption was not carried out within the time limit, an absolute sale was to be assumed after a reasonable period of time. An answer from the Ministry of Justice of November 1951, on the other hand, did not provide for any time limit on redemption, but stated that the redemption could take place at any time after the contractually stipulated term of the Dian had expired. Then there was a joint circular issued by the Supreme People's Court, the Ministry of Finance, and the Ministry of Justice in 1952, which stipulated that if the contractually stipulated term of the Dian on a residential building had already expired for more than 10 years, without the Dian debtor having claimed redemption, the Dian creditor could request the latter or his heirs to sell the Dian object against payment of a subsequent payment. Then, in an opinion from 1963, the SPC stated that in the absence of a contractual redemption period or forfeiture clause, an equitable solution must be found. In an opinion from 1979, the SPC also again emphasized that the actual needs of the contracting parties must be taken into account when solving such cases. So we can see that in the early decades, it seems that the decisions of the SPC were a lot influenced by what I would sum up as social considerations, like in light of the existing housing shortage, like who needed the place most. In 1984, the case law of the Supreme People's Court changed. In an opinion from 1984, it stated if the redemption takes place 10 years after the expiry of the contractually determined term, or if the Dian contract does not contain a provision on the term of the Dian, after 30 years after the expiry of the contractually determined term years, this is generally regarded as an absolute sale. According to case law of the SPC, the term of the redemption period could also be suspended or interrupted by certain events and circumstances. Examples in SPC cases are, for example, if the Dian property was expropriated by mistake, when a private residential property was expropriated and the Dian debtor was therefore unable to redeem it, then the period of expropriation is not included in the redemption period, as redemption was not possible during this period for objective reasons. So there is a suspension of the redemption period. This is one example of cases where redemption period was basically suspended or interrupted. Yeah, almost done with my presentation. So how is the current situation? Over the past decades, the PRC legislature has issued a large number of laws relating to civil law relationships. I had already mentioned the Minfa-Tongzi enacted in 1986. Then in more recent times, for example, the PRC contract law enacted in 1999, and most recently the PRC civil code enacted in 2020. And the Dian is not mentioned in any of them. I submitted my paper for my thesis in the mid-90s. So the time period I covered in the PRC was until the mid-90s. The last SPC decision I found was from 1994, and I did not follow up with the development of the Dian in the PRC afterwards. When preparing this lecture, I did a brief research and I did not find any court cases from the period after the early 1990s. And taking into regard the enormous economic and legal developments in the past decades and the development of the real estate legal system and the real estate market, I think that the Dian in the PRC currently no longer exists. It has been replaced by rental relationships and mortgages, both of which are subject to very extensive regulations. But maybe I'm wrong and didn't search thoroughly enough. Maybe somebody still finds some court decisions that have been issued after 1994. The Dian is still existing in Taiwan's legal system. It is still regulated by statutory law in Articles 911 to 927 of the Taiwanese Civil Code, the MINFA. And it is also subject of court decisions and legal commentaries. However, I also did a private research in preparation of this lecture. It seems its importance in actual legal life is nowadays very limited. A publication from the PRC reports that hardly any new legal Dian relationships are established in Taiwan. And I did not do any research of the current court precedents and practice in Taiwan. So I would like to end my lecture with an idea or suggestion. If you are still looking for a topic for a thesis or article or paper, maybe it's worthwhile exploring whether there was still case law in the PRC on the Dian after the beginning of or after 1994, and how the case law and current practice on the Dian in Taiwan is. So that's the end of my lecture. Thank you very much for staying with me for 1 hour 15, and I'm happy to answer some questions.
Thank you very much. That was a fantastic lecture and full of interesting ideas and discussion of doctrinal concepts. We already have some questions, but if there's anybody in the audience who wants to ask something, again, please use the chat function and chat them in, and I will ask them. If I may, can I start with one question myself? You mentioned only in half a sentence or in one sentence that the Dian, the origin of the Dian was that there were social taboos to sell land, that developed or that caused the development of the Dian as a legal institution. Could you elaborate on that? What was that?
Yeah, it was in an agrarian society. In an agrarian society, the land especially is the most valuable assets of the entire family. And I think I had also mentioned in half a sentence that, I had mentioned that there was, for example, a priority right, a right of first refusal, if a Dian on land was established of the relatives and neighbors. And back then, when I was done my research, I found there were also some opinions that explained that selling basically the basis for the living of the family was totally taboo. And also over long periods of the traditional Chinese law, it is pretty difficult to distinguish the Dian from the sale with the repurchase option. So it seems that the terms were sometimes mixed up and also not really clearly always distinguished. The conception or the theory is that both legal institutions were developed because there was also a taboo of selling land, so the livelihood of a family for good and forever, so to say. And these were the measures or the circumventions which were then developed to still achieve a marketability of land, and somehow maybe some parallel to current law, because as you all know, ownership in land in China does not belong to the individuals, but it belongs to the state or to collectives. But then in the 1980s, the PRC developed a system of land use rights. So ownership cannot be transferred in land, but land use rights were developed, which span for a certain period of time. and they can be acquired and transferred and mortgaged and rented out. So this is also kind of circumvention model to achieve marketability of real estate in the end. And in my opinion, probably the Dian originally developed out of similar interests.
Thank you. Perfect. Two questions from the audience. I wonder if there were, I think you have answered the first one. I wonder if this relates, I think, as far as I remember, to the Qing situation. I wonder if there are any provisions for the term of the Dian, if there are no restrictions, what is the difference between Dian and selling in a lower price if the term is long enough? By difference, I mean both in the legal sense and in practice. I think you have answered that after the question came in because you've discussed the terms of the Dian, and you also spoke about the resale option, I think.
Yeah, I mean, basically, it's the term of the Dian. The term marks the beginning of the redemption period always, and if everything goes well, so to say, then the Dian can be redeemed based on the original price because there is no interest payment. But if there are some situations, and I think I've described some details. For example, building burns down, building is damaged, etc. Then there are stipulations under customary law or partially also under later statutory law, like in the ordinance from 1915, how the damage basically is divided.
Thank you. Next question from our old friend, Professor Benjamin Pissler. Thank you very much for a stimulating talk. My question is whether there are not also more recent indications that the Dian still plays a certain role in China today. You mentioned that at the end. I think the question came in earlier.
Yeah. To be frank, I do not know. I have written my thesis 30 years ago, and since then put the book into the shelf and only revisited this topic now to prepare the lecture. I submitted my thesis, I think, in 1995. So I considered everything until the time when I submitted my thesis. I could imagine that there are still some decisions afterwards, like in the 90s. But this would need to be further researched. I'm absolutely convinced that nowadays no new Dian is established because we have now for almost a decade, I would say, a modern law system. Also, as you can see, most of the cases which the Supreme People's Court handled in the first 4 decades of the PRC related to Dian relationships that had been established in before 49. So in other words, on buildings already existing back then. And when I look around in Shanghai, or I look out of my window here in our office and see the urban redevelopment that has been going on in the past 20 years and is currently still going on and in parts accelerated, my guess would be that the buildings on which the Dian had been established in the meantime are probably all torn down, and the users or the heirs of the original Dian creditors have been resettled. They got compensation from the government when the buildings were torn down. maybe it's interesting to have a look, because theoretically speaking, if there was a Dian on one of these buildings that got torn down for a shopping mall, if there were still heirs of the original Dian debtor, who then also wanted to have a share of the settlement compensation. Maybe there are cases. As I said, my research ended end of 1994. I had a quick look in preparation of the this lecture, but neither myself nor one of our interns who volunteered to help found anything. But we were not digging very deep, so cannot exclude that maybe there is still one or the other case. Probably not on SPC level, but maybe on local on level of the local courts. As I said, maybe if somebody is interesting, maybe an interesting topic for a thesis or an article.
Thank you. Professor Pissler actually made additional comments. He said probably there is a 2020 Supreme People Court's interpretation of the security systems, and there is something in Article 63 which is similar to a Dian, but we don't want to discuss this here. We have one last question from Eugene Theo. If the property was expropriated, the then price still have to be repaid? That's the first question. That was after a revolution, of course. And was there any allowance in the Dian price for inflation?
If the Dian property was expropriated, and that was then no redemption is possible at all. Redemption is only possible if the expropriation was by mistake, so to say.
So who lost out in expropriation? Somebody have benefited from the expropriation, apart from the Chinese state, of course.
No, it's the Chinese state, and then the Dian debtor, who was, if they were a rich landlord, or or one of the, what was it called, 9 classes, one of a rich landlord or capitalist, they lost out. Yeah. And I have not come, or I don't remember coming across any statement in the SPC cases on inflation. Maybe the reason being that in the early years of the PRC, there was no inflation, or at least no official one.
Okay, time is up. Thank you very, very much for this very interesting talk and the lively discussion. I'm glad that we brought you back and forced you to revisit your doctorate thesis. I have certainly enjoyed this, and I hope and I trust the audience has as well. It remains for me, for the time being, to announce upcoming events here at CUHK Law. If Jay could share the slides, please. First, the next in our Greater China Legal History seminar series is a talk by Dr. Christopher Munn on deportation in Hong Kong history. That will take place on the 21st of March, 2025, same time. Next. Then we have a book talk by a visiting professor, Professor Vincenzo Barroso, from the University of Manchester, Debt Capital Markets, Law, Regulation and Policy, 4th of March, 12:30 to 1:45. And our Center for Legal Innovation and Digital Society organizes or has organized a talk on opportunities of the digital age, law, technology, commercialization, entrepreneurship by Dr. Yu on the 7th of March, 2025, also Friday, 6:30 to 7:30. And finally, our colleague, Mr. Jonathan Glueck, will talk about possessory rights over human remains in Hong Kong. The date is the 12th of March, 2025, 5 p.m. to 6 p.m. We, of course, hope that all of you will participate. Again, Ulrike, thank you very, very much for the great talk. Thank you for everybody else for joining. and we hope to see you soon again at one of our talks. Thank you and goodbye for today.
Thank you very much. Goodbye.